it strikes me as you all are saying this, it is interesting, especially the national angle. You think, what was it? Was it 2019, I guess, when some of those reviews were coming out saying, here now, China has the most patents in 5G, and then other studies would come out saying, no, that's not how you count it, or it is about contributions, not about patents, and it's about tying those together. I wonder, have any of you seen, does what is happening on the patent side mirror in any way what's happening on the contribution side? And I ask that not knowing who's even got insight into that, but I don't. I'll admit that.
So maybe I can start and kick us off on that one. We have the benefit of going to different companies and seeing what patents they actually have that they're able to map onto the standard. So rather than relying on third-party reports, we actually see the real good stuff ourselves. And from my perspective, when we negotiate with really any counterparty, we do see a correlation between how much have they invested, right, in the research, in the standardization process, how much have they invested, and what do they actually own that's of value. And in that sense, I'm speaking in terms of what actually maps onto the standard. And so those who contribute less, show up with less, and those who contribute more show up with more. So there's this broad correlation that we do see between, contribution or investment generally in R&D affecting the space and what they ultimately show up with. So we are seeing that. That's why when there are reports, that are way off from that reality, it sort of raises a lot of eyebrows, I think, among the community who's licensing, and I'm curious to hear others' perspectives on that. But that's at least my own.
Yeah, I have seen. I've been in licensing conversations with many of the major players, and a number that were kind of on the fringe. And again, it depends on who you're talking to, but as to that, and I certainly understand Patricio's standpoint. Again, the contribution angle is certainly a relevant one, and I think that more and more folks that have invested heavily in that context, in terms of R&D spend and moving people back and forth to standards bodies and contributing on the back end, are taking that approach. But again, not every asset is created equal. So there's plenty of padding that happens in that context across the board. And so, but that has, over the last probably 5 or 6 years, certainly seen more and more of people highlighting their relative contributions in various areas of the specification for one reason or another.
How about you?
Well, I think I guess maybe the only additional thought that I could add, thinking about some of the contributors to up and coming pools, or maybe contributor is the wrong word, but folks that are identifying assets that they own, relative to the pools. It does, I think, to it might run a little counter to some of the points that Patricio made. Not that I disagree with him, but I think there are a lot of folks that would claim that although they haven't contributed to the standard, they have some fundamental technology early on. And I think when there's invitations to to contribute patent assets, you see those things come out. And I think that's been sort of an interesting perspective. And I guess one that comes to mind in particular is if you look at the Avanci landscape, there are lots of folks there that I think you wouldn't necessarily peg as big contributors to some of the later standards.
Yeah, I mean, Aaron, and it's a really fascinating side of this, which I think has become more to the front of 5G, which is the notion that parties that before may have wanted to stay out of FRAND licensing, to try to extract a larger than FRAND rate by not agreeing to it, have seen the benefit of belonging to the club and saying to courts, especially in the United States, FRAND is fine for us, but now we get to be a part of it and we get to go to the meetings and we get to see what's happening. And there's that has been, in my mind too, a big shift where not just that there's a wider variety of companies involved, and but it says, to all of your points, it's what companies are involved and what their purpose is there, has created some very interesting situations, I think. Not the least of which, Aaron, as you brought up, but pools. And I wanted to ask you all about this because, Ericsson is involved in a pool, more than involved, right, in Avanci. But pools have had an interesting history, especially in the United States, of their kind of place and effectiveness in varying standard essential patent areas. I guess first off, I was wondering, do you all see pools as having a increased or decreased importance in the 5G space compared to previously, in trying to tackle the problem of licensing? Aaron, what do you think?
So I could imagine that pools, or maybe something that is another type of collaborative pro-competitive effort, that might not look exactly like a traditional pool, would gain in importance and kind of if not market share, at least reach in the participants. And the reason I say that, and this might touch on something that we'll get into a little bit deeper, is I think in this 5G landscape, we anticipate so much more data movement, so many more connected devices, so many more players, and in the case of Avanci, they've focused on connected cars, but I think you could imagine that for industrial IoT or commercial IoT, or even smart homes. And with so many different contributors in the market, it's hard for me to imagine a concerted licensing effort that's administrable without involvement of pools. So I guess that's a long way of saying I see those types of tools as increasing in importance going forward.
Patricio, what do you think about it? I mean, obviously you all are part of one, but I guess that doesn't necessarily say, where you think it's heading in a few years.
We've actually been part of several pools. Avanci is one of them. I agree with what you said, Aaron, that as there's increased market fragmentation, whether on the patent holder side or on the implementer side, there is a need for an efficient way to address the licensing aspects. The problem or the challenge that I think the pools are experiencing is, does holding out for these fragmented markets, is that a more economically attractive option than simply taking a license from the pool? And I think that's something that we're kind of in the middle of the story on that one. Like the courts are looking at this and seeing the need to address this avenue of not going to the pool, not taking bilateral licenses, just having this other economic option. Thinking about how to address that, and it really does need a regulatory approach that really favors a strong patent system. And without that, then you're not going to have successful pools. It's going to be a much more challenging, fractious environment. So I do see a need for pools going forward for the reasons Aaron mentioned, but it also needs a strong, let's say, patent regulatory system in the background to support the pools and make them economically attractive over simply just holding out.
Mark, I wanted to hear your thoughts on it. I was also wondering too what you thought. Is an MPEG-LA style approach ever possible here? And by that I mean that notion that every patent that comes into a pool is reviewed for essentiality independently. I've certainly seen estimates of doing that with 5G that reach quickly into the billions. Have you thought about any of that sort of thing?
And the practicality, I think of that. I mean, again, there's arguably, 100,000 plus assets, that, to your point, that gets to be quite an expensive task to review individually. Again, with, prior experience and dealings and the practicality of the situation. Again, I think that pools play some sort of role, or aggregators play some sort of role. But my fear is that, like we talked about a little bit earlier, given the degrees of fragmentation in the marketplace and a lot of this more nationalistic type of approach, approaches that are kind of coming to the forefront, I fear that getting the required gravity around any individual or organization or entity that would be driving this, I think is difficult. And not to say that it's impossible. I just personally don't see it happening. And there's always going to be a third party vested interest to hold out based on some future court decision that we haven't contemplated yet for one reason or another, specifically with everything that's going on in the UK courts, German courts, Chinese courts, that uncertainty could, in my opinion, throw a wrench in that mechanism.
By the way, on that last point, I was wondering where do you all see the 5-year litigation horizon? Like where is going to be important? Is it gonna stick to whatever it really is now, US, Germany, China, UK, you could create a mix, but I was wondering if any of you all see where you think it's going to be in a few years. Mark, you have any thoughts?
Yeah. Again, I think that the UK has made a statement. They're pretty much open for business on this context. Anyone who's been involved in litigation, and I'm involved in 10 of them right now, realize quickly that it's certainly not the best path forward. Certainly even to collect, to be perfectly honest, because of the appeal process and various other obstacles there. But I do think that the Chinese courts will play a more significant role going forward. I think that they've established themselves in that context, certainly, and a handful of other geographies that are realizing the significance of those type of decisions being made in their respective boundaries will come to the forefront as well. And so I think we'll be surprised. I think you'll see some other courts, some other government-related interests step forward and make a statement in that context, just to draw attention to their situation or their respective companies' situations.
Patricio, kind of on that topic and regulatory action, do you see any indication of litigation being tied into that regulatory effort of looking at, should we be examining what effect litigation in our country can have on these larger FRAND issues?
From a let's say a government perspective,
Right.
or yeah, so it may be the case that that's happening, for example, in China, to express, maybe their voice more strongly on issues regarding FRAND in particular. I don't know if other governments express themselves through the court system necessarily, but just to follow up a little bit on what Mark was saying, you know, one thing we should keep in mind is the UPC is being, you know, is going to start going forward, and I think that more unified patent court system could have a strong voice as well. I'm not sure that the government would necessarily, you know, have an impact on whether litigation drives things, but I do, you know, see regulators, you know, some regulators in the West wanting to step back and see how the courts deal with issues before bringing, you know, regulatory actions or, you know, bigger cases against, in particular, patent holders. I think they're waiting to see, can the courts essentially treat this effectively as a contract issue? And, you know, my hope is that they're finding that they can, but so maybe in a sense, just to go back to your question, Mike, maybe the governments are holding back a little bit just to see how the courts deal with issues before stepping in either with regulatory actions or with changes to the patent law.
You know, it's interesting, Patricio. I was involved in some discussions. I guess maybe 2 years ago now. There was another group that was trying to push the notion that pools should be mandated in certain areas, and I'm sure you know, and some of the lobbyists here in DC could not have cared less. It was nowhere near even the putting it on a sheet of paper to pass by anyone's desk. And I don't think that's gotten any different at this point. I just don't think anybody, here in the US at least, sees it as any possible winner anyway going forward. So, but that's an interesting one. I wanted to move to some 5G going to other areas. I did want to run a quick one by you all, because I think a number of this audience is kind of involved in this space in a way that they may get approached about portfolios or know about portfolios by thinking about certain things, and sometimes there's an assumption that there is a way to look at all the patents and understand what's what, and it goes along with what Marky and I were just discussing. But I'm wondering, have any of you found either, something that at least labels itself as AI, which many do, or some kind of manual review on a large scale has proved effective for you? In trying to determine, is a group of patents important to us? Have any of you been through that?
I guess I'll chime in there, Mike. The short answer is no, but yes. I mean, I think that's something that we're at Micron. We're continuing to look for a solution that would be helpful there. So certainly, we do use some tools that I think are could generally be characterized as AI for helping us look at our own portfolio and look at portfolios of others. But it's still it takes a lot of people hours to get a good read on it. And so I'm not aware of anything that's sort of off the shelf that that would be a substitute for a professional review of anything right now. And certainly if anyone knows of them, I'd welcome that. But yeah, I think as much as AI tools are helpful, and I think they're becoming increasingly better, it still does take a professional view to characterize these things in a meaningful way.
I completely agree with that. I think AI tools are still sort of assists on more on activities that require more intelligence. And right now, whether it's essentiality checks or really trying to understand how many essential patents there are, it really requires a manual check. It's too difficult for AI right now to do something that's rigorous, reliable, believable. So one thing we've done, just as an example of what someone could do or rely upon, is we've tried to do surveys essentially of, and really to answer the question, how many essential patents are there in industry? Because it affects us, on the on the licensee side, just as it does on the licensor side. And so we've actually published a couple of studies that people are welcome to review, but we've used technical experts. We've disclosed our sponsorship, disclosed who they are, these technical experts, what their backgrounds are, disclosed the methodology, disclosed how much time they took to do the review, and essentially, the statistical sampling, the error bands, all of it, and put it out essentially for people to reference and look at. And I think that has been helpful as a tool to guide us on, well, how many essential families do we have compared to the rest, and how many does the rest have at any particular point in time? So if anybody's interested in that, the author of those papers is a gentleman called Dr. Cooper, and it's on SSRN if people want to find that. So we did one for 4G in 2019, and then we did one for 5G that we published in 2021. They're also on the LES, in the LES magazines if people are interested in looking them up there. But that's something that's helped us. So manual review of answering the question, how many essential families are there for a particular product segment for a particular technology?
Mark, I mean, how important is it that you can see, the actual mapping of a patent to the standard in a license negotiation? Or is there, I mean, I feel like even over my career, there's been this attempt to map to standards and then don't map to standards, map to products. I think we've crept a little bit back towards map to standards. I don't know what you've seen, in your.
Yeah. I mean, again, overall, I ran a pretty substantial organization in that context, and like I said, we'd had conversations with all of the major licensors and licensees, and I got to believe fundamentally that people want to see the mapping to the standards in excruciating detail, and we spent a lot of time and effort hardening our processes around charting to the specifications and leaving as little doubt as possible with regard to the individual reads and the context and syntax. So I personally think it's very important, and like I said, I developed very stringent processes to harden those very assets so that I could have a meaningful conversation, because without them, I think it's very difficult to really have a earnest conversation about a third party's products or services.
It's funny. It's almost, sometimes you almost think you might rather have 5 than 500 patents, because you can explain those 5, and sometimes I'm not so certain the value is that different, right? It's just.
That's, yeah, I second that thought process as well. I'd rather have 5 good ones. But the reality of the situation is, if you're going to go out into the wild and you're going to have those conversations, then again, I always viewed it as as a respect thing. If I'm going to ask something of someone, then I'm going to make sure that I have all my T's crossed and I's dotted in that context. And for the most part, through those licensing conversations over the years, we kind of had to develop a bit of a reputation for having solid processes and around hardening those types of assets. So, and I know Ericsson is prides itself in a similar capacity. So,
I mean, claim charts really are a sign of credibility. Are a sign that you actually, own relevant assets of quality. So I completely agree that you have to have claim charts, and you have to show claim charts in our industry right now to be taken seriously.
Yeah, it's an interesting investment, right? If you're not willing to make that investment, I think it is very hard to convince somebody that they need to take you seriously. And honestly, that, I know that from even the monetization side of things. It's, if you don't have everything lined up in detail, there's no reason anybody should pay any attention to you. And of course, that, like I said, that's easier with 5 patents. It's a very, very difficult thing when you've got thousands and tens of thousands and you're trying to choose from them. But so I definitely don't envy that issue. I wanted to talk a bit about 5G and outside the cellular wireless industry, because I think that's a very, very interesting change here, where you now are getting into different verticals, not just, I guess what you'd call licensing verticals, but also in some sense patent verticals, where you have different pieces of the standard that are geared more towards certain other industries. You have a piece of 5G that is more geared towards automotive, by name. You have there is maybe more of a blending between cellular and what you think of as IoT, because some of the same concepts are simply being used there, or there wasn't a lot of specialization there. But Aaron, I know that Micron is facing this from the semiconductor space, so I was wondering how you all are looking at that problem of taking this into different verticals.
Well, I mean, we really view the 5G world as, as many people do, as this incredibly data-rich world. All the benefits you mentioned about a 5G world create this data that has to be computed on and moved around and stored on the backside. So obviously we think about 5G usually from the wireless interface side, and that makes good sense. But now with all of these connected devices and connected cars, there's another interface to think about on the backside. And so at Micron, when we're thinking about the world of SEPs in 5G, it's also about memory interface standards and compute standards and information and data security standards, and all of those are coming into play now. Maybe a salient example, with the enablement of autonomous and semi-autonomous vehicles, there's a long-standing standard for functional safety in automotive. It's an ISO standard that deals with kind of the reliability of electrical components in vehicles. Historically, computer memory didn't factor hugely into that, because if memory failed, it was certainly a problem from a customer relationship standpoint and quality of experience standpoint, but lives weren't at risk. But in this autonomous driving world, memory can't fail if a car is being driven autonomously, and so that's led to other standards that are implementing these functional safety standards in the memory space, and that's something we're looking at. We're launching products in that area, and for the past close to a decade have been ramping up our patent portfolio in that area. And that's something I think that doesn't get a lot of airtime when we think about 5G SEPs, but that trend I think is likely to continue in this new world.
It's interesting because automotive is always an interesting example, because you've got a platform, not unlike a cell phone, that has a bunch of different technologies being put in now more than ever, different, and of course an industry that is very much not used to pain in the way that other industries are used to for that technology. But even just what you were saying, Aaron, reminds me of the, in the US we have some of those auto cases where people were attaching larger values to things that were crucial to the operation of the automobile, no matter how small or inexpensive, that they deserved a far greater share of the royalty scheme because of it. And now, as opposed to brakes, we're shifting some of that onto silicon, and it'll be interesting to see there. I mean, I know, Patricio, you obviously have dealt with this a lot, because you've got even Avanci has its stated automotive rates. It's got kind of a IoT matrix that it's trying to develop, to recognize those different areas. Where do you think we are now on trying to understand what different verticals should be drawn that makes sense in a licensing space?
I think we're kind of at the initial phase of that still, in understanding first, what verticals are really going to take up 5G. I mean, there's some that have started outside of handsets, like fixed wireless access, connecting homes, but also you have laptops, and you have a couple others that are starting to explore 5G. So we're kind of at the very initial phase of it, and I do think that there's a desire to address licensing in an efficient way in those segments, but we still, until the vertical comes out and the value proposition is clear, it's really hard to price it. And so I think these are the kinds of conversations that we're starting to have. And I think, pools are starting to consider whether it's worth addressing those segments. But like I said, we're still really early in the process there.
Yeah, it reminds me, I was at a big auto conference, I guess, well, pre-pandemic, so 2019. And I had mentioned this before, and the understanding of what essential means is very different when you are amongst a group of people who are familiar with the cellular wireless world, and then when you're outside of it. And even Aaron, you mentioned the ISO standards, those sorts of things. I saw an hour-long presentation on what essential patents are, and the entire presentation was, if you have a patent that covers a product, it's essential. And but and not to fault them, it's just there's a real, I think sometimes you forget when you step outside your world how people aren't used to this, and they see 100,000 patents, and they see 100 companies, and it's dizzying. Mark, how are people trying to who understand what essentiality is? How are they trying to bring that to other groups and help them understand why they're called essential and what it means to licensing?
Yeah, well, again, it's interesting across a handful of verticals. Again, I personally transitioned from the telecom world to the kind of healthcare life sciences world, where there's a great deal of mobile related technologies, memory at the edge of the network, high performance computing and such, that are leveraged. I think the same has happened, obviously, in the automotive space and a handful of other verticals. And you're starting to see people that are over the last, 2 to 3 years, a number of folks transitioning, into the automotive OEMs and tier one suppliers, or to some of the larger kind of connected device companies that have been involved with the Ericssons and Nokias and Blackberries and Sonys of the world. And so I think that education is taking place. Again, I was very, very friendly with a number of the OEMs on the automotive space, BlackBerry, because of our QNX offering, which was pretty much in every vehicle on the planet. And so I had a lot of time to spend talking with the CIPOs of the major car OEMs and a number of the tier one suppliers too. And I think, and probably initially they didn't want to have the conversation, didn't shied away from understanding it, but realized quite quickly the relevant importance of it, and have invested consequently to make sure they get their head around it. And I have to believe that regardless of how the SEP chip falls, that they are beginning to arm themselves appropriately with non-standards essential patents in a meaningful way to combat, what the imposing storm that perhaps they face. So I think that they've, at least in the automotive space, they're educating, courtesy of a number of former colleagues of ourselves, and spending time and effort and getting up to speed quite quickly, and are beginning the process to make sure that can have a meaningful bilateral conversation. That's just my personal opinion. So I think it's happening.
Yeah, it's interesting. I mean, without asking for comment on it, it was, you know, when an automotive crowd hears a royalty rate of, I can't remember what it was now, was it 15 per car?
Yeah.
You know, they laugh because it's unbelievable to them that somebody thinks $15 a car isn't an enormous amount of money. When from outside of that, you say, but this is a $50,000 item. How can that matter? And
Yeah.
it's these different mentalities coming together that I think are very interesting to watch.
Yeah, if you never had a discussion with procurement from an automotive OEM or tier one supplier, then I can see why you would say that. So anyway,
No.
yeah, every penny counts, certainly.
Yeah, and you know, it's I think for you too now, you know, it's the same kind of thing. You have items that all have different kind of cost and price structures. It's no longer, you know, a lot of the same. You know, I think it'll be interesting to see how those verticals play out and whether the pools, you know, form to attack specific verticals in an effective way, which I think was some of the intent behind, you know, some of the earlier ones in this particular space. But
Yeah, I think honestly, I think that from in a handful of the verticals, it's got to be more use case driven. There's certain use cases that certainly drive value, right? Not every use case is equally important for one reason. Things are nice to have versus necessary and essential to have and such like that. And so, regardless of the pools kind of or aggregators focus on a particular vertical segment, I think they do have to take into consideration that aspect of it. And I think they'll get a little bit further quicker context.
yeah. But by the way, we got two kind of interesting questions that are relevant to this that I'll just relay. I think I know the answer to these. Patricio, I suspect you would too, but if your technical submission comes in under one entity and the patent's held outside, you cannot treat those as separate for your FRAND obligations, correct? I think. Well, maybe that's asking too sensitive a question. I'm not realizing it. I don't know. You can, now that I'm asking it, I'm thinking, I don't think anybody wants to answer that. But generally, I will say, I believe the way it is that's certainly not the idea. The idea is that if you are playing the game, that you're playing it up front and that you are going to be a part of the technical submissions and you are going to disclose all the patents that you have an interest in. And I will say, I think that is how most of the major players tend to play the game. You know, at least that's been my experience. I don't know that there's a lot of benefit outside. You know, it's interesting because this question in my mind does raise the notion of unbundling in patent context, which was raised. I'm trying to remember. Someone wrote an interesting article about it where, you know, the notion that companies would be incentivized because if it's too hard to license 5,000 patents, and you're only going to get X dollars for those 5,000. If you split them up, send some to pools, keep some, send some to privateers, send some to unrelated entities with kickbacks, you will end up with a larger whole. You know, that just seems like a lot of trouble too. Like to even figure out how to do that may ruin a lot of your whatever you think you could get from it. And you're relying on so many people to get that number. But the other question, by the way, is similar. If you can you submit contributions in the car vertical? Now, I mean, I think it's the same. These two are somewhat the same. If you have a technical contribution, meaning you are part of the organization, if you have a patent that covers that technical submission, you are supposed to declare it. So, I think that's the general feel, but I got to be honest, I'm a little loose on the exact rules, which may be the general statement on it anyway. A little loose on the rules.
Mike, one thought, this is not directly in response to these questions, but it might be somewhat instructive. So, and I think also kind of goes to your question about, how do you talk about essentiality? So, outside of the 3GPP and 3GPP organizational partner context that is maybe, well, definitely more mature than many of the standards organizations we're seeing come up in the last few years. I think there's a trend in a lot of newer standard setting organizations, at least in the compute space and kind of data security space, to have similar definitions of essentiality for claims, and to anticipate some of these ideas about wanting to license in certain use cases and exclude certain use cases. And so I think you're seeing more and more SSOs kind of account for some of these things and potentially heading off some game playing, I'll call it, in their membership agreements.
Yeah, that's interesting. I mean, certainly both of these examples have been tried. I think they've just been tried on a much smaller scale, so far. And then, of course, I mean, I guess interesting is maybe on a broad spectrum, but it is kind of fascinating to hear what happens at the actual meetings for the technical, when the technical discussions happen, and the breakout rooms and the factions. And it's part of what I think makes this area real interesting, because you take a technical submission, which may be covered by a patent. Those are two very different sets of language in those two, but the technical submission will go into the washing machine that is the meetings and come out probably by intention looking very different. And now you've got to connect that initial patent to the final, specification. And it's part of what makes all of this so difficult to understand, I think, when you're outside of it. And then when you're inside of it, you truly understand the scope of the problem facing you. Which sort of leads us kind of here at the tail end here and we'll just kind of close it up with this, but 6G, I mean, we're still in 5G, right? We still, I mean, it is funny, the releases, you've got, it's not like 4G and 5G were a bright line in terms of the releases. It was kind of a half at a point there. So we've got release 18 is 2023, 6G, is it 5 years? Is it 10 years? I don't need, it's hard to know. Do you all find that 6G is being discussed in terms of licensing at this point, or is it too early yet?
Early. That's the easiest question you've asked so far tonight. It's much too early. It's a buzzword. It's not connected to a standard. People are starting to explore what the services will be that need to be addressed with the next generation of technology. So we're at like the very earliest of stages here. And it's just being thrown around. I mean, I'm seeing some patent studies on 6G, and I'm just like, shaking my head in my home office, just kind of chuckling a little bit, because it's way too early. And so from our perspective, 6G will likely come out in the 2028 to 2030 timeframe. So there's a long way to go still.
Do you all see any impact of the, I can't remember if we discussed earlier, but the 4G cross designation has been a topic where, a lot of the 5G essential patents were 4G essential patents that were then cross designated into 5G. And, for certain companies, it's a large percentage of their declarations are patents that started with 4G. Some go even further back, right, depending upon whether they're still alive. But, my impression was that had, some impact on licensing in terms of this notion of, you've got some people were getting away with 4G licenses, right? Where the license was limited to 4G products. All of a sudden, a 5G product comes along that is using the exact same 4G products, and well, now you need a new license because that's a different product. I think that issue in particular is going to be rare now because I can't see anybody's going to enter into a 5G only product license. But have you seen that cross designation of patents come up in any way? Any of you?
I've seen it with third parties looking to pad their numbers effectively. In my opinion, I've seen a handful of companies that didn't make the investment and were trying to grandfather in as much as they possibly could. It's the reality of the situation. So it kind of lends itself back toward the scenario where you really do need a independent third party that's testing of sorts, because again, this notion of over declaration or overextending from a prior generation, I saw it to a lesser extent maybe in the prior standards, but from 4G to 5G, I've noticed it a number of times, almost to the point where it's a little embarrassing, I think, for the parties involved.
Yeah, I mean, the IPlytics, and I think maybe Tim might be here, but they've got some interesting numbers on that share of 5G patents that were, not declared previously, and it's a very interesting kind of chart just to see who's got newer and the attempts to tie that to contributions too, which is another interesting way to kind of companies have taken to show why when they say essential patents, maybe they mean something a little different than some other companies. I mean, it's interesting about 6G. I guess no one certainly disagrees on that, since there is no such thing as 6G. It is interesting too, and Aaron, I just had one more question I want to run by you in particular, but I think it's fair to say 5G has shifted more prominence towards software-based solutions in the standard. I think that 4G was more chip heavy, and I think now it's more software heavy, and some of that has to do with the white box push of the AT&Ts of the world and some other efforts to get more upgradable systems when they really were, I mean, it's no secret, I think they're trying to push away from proprietary chips, but how do you all view that? Because in some sense, you all are still that side of the semiconductor space that's providing, as you said, those kind of essential elements.
I mean, certainly, Micron is a semiconductor company, but I think more than that, and I think that probably others in the space would agree. It's really much more about using semiconductors and systems that are managing this data. So I think there's a push, certainly at Micron and then others in the semi space, to provide differentiated kind of system level solutions. And so I think that the line between companies that are squarely in the hardware or software space continues to blur. So in terms of how that affects licensing, maybe that's a non-answer, but in terms of how that affects what we're doing with our patent development efforts, I think it's we're placing bets across the board.
Yeah, that's interesting. Thanks. I mean, I think as it's a little bit after, so we can kind of wrap up. I'll just say from my standpoint, by the way, I appreciate all of you, because I find this notion of how to license in a 100,000 patent space to be incredibly fascinating, and it is a real problem that is, I think, generating some some, very interesting solutions from a lot of different angles. And so it's kind of fascinating to watch. And I appreciate you guys coming today and kind of sharing your perspectives on it, because it's not often you get people that are actually deep in it to talk about it. So thank you all.
Mike and everybody.
Yep, thank you.
Mike.
Way to go, Mike.
Gentlemen, for joining us. So it falls to me to thank Patricio, Aaron, Mark for sharing their insights, and to Mike for facilitating a very insightful discussion. We will now take a short break of 10 minutes where we will welcome you all back for 5G licensing in focus at approximately 11:15 a.m. local time. Thank you again, speakers. Thank you so much.
Thank you.
Welcome back, everybody. Thank you very much for rejoining us for the second of our insightful morning discussions, 5G licensing in focus, which we can all agree is a great topic to sort of end the AM sessions on. So, quick reminder for those of you that are rejoining for this, please use the Q&A function, which you will find on the menu bar on the right-hand side under the 3 dots to ask any questions of this group of speakers. That's enough from me. So, Rob, over to you.
Thanks, Rebecca. When IAM came to me and said, well, we'd like you to be on a panel about 5G licensing, I said, I really don't know this topic very well. And they said, no, we don't want you to be on the panel. We just want you to introduce the panel and moderate. We'll find people that actually know what they're talking about. And unfortunately, they didn't lie to me. So I'm Rob Calico. Today, I am joined by Akiko Akari of Akari IP Law, Patrick Hemmerin from Nokia, and Gojun Zhao from Intel. Before we begin, I'd just like to sort of, indicate for the panelists and for myself, what we'll talk about today is sort of our own personal opinions. None of this should be, the sort of thing that'd be tied back or some sort of official company statement. This is just, for IP professionals having a discussion about 5G licensing and some of the issues that we see in that area. So with that, I'll kick it off. IAM sort of came to us and sort of had 3 high-level topics, which were essentially, litigation or collective, stated simply, it was 5G royalties on market rate, recent court decisions and how those are impacting negotiations, and collective licensing solutions. I think for me as a litigator, one of the things that I always like to think about is, what does the case law background look like, right? That's always the backstop for any sort of negotiation. And so, Akiko, could you maybe walk us through some of the more recent decisions that we've seen from some of the various territorial courts on CEP negotiations and that sort of thing? I think you might be muted. Sorry.
Okay, sorry. Can you hear me?
Yeah.
Great. Thank you, Rob, for your great introduction. Okay, I'm happy to talk about relevant recent case laws he just mentioned. So before going into the detail of these case laws, let me briefly explain the background of these issues. So as many of you know, in the SCP world, it is a common practice to negotiate the worldwide global portfolio licensing rather than the country-specific licensing. The global portfolio license would include patents granted in multiple jurisdictions like so Taiwan, China, Europe, US, and Japan, like that. So in the course of that licensing negotiation, if the dispute arises, then which country's court the parties may want to use to resolve such international disputes is a very big issue. And I want to talk a little bit about the relevant case law in this field. Okay, thank you. So first issue is this. Whether one country's court may determine the royalty for the global patent portfolio, not the specific one country. Here you can see a conflict as described in this slide. So, the scope of the patent right is limited in one country. So let's say Taiwan's patent office may grant Taiwan patent. The scope of that patent is limited in the territory of Taiwan, right? So the territorial scope of the patent right is country basis. On the other hand, as I just described in the previous slide, the practice of the SCP global patent portfolio licensing has an international nature, not limited to the territory of one country. So in that situation, the question is whether one specific country's court may determine a licensing fees of the global patent portfolio as a whole. That is the issue here. For that, I think that many of you know the UK court handed down the very important landmark decision. And then UK court responded that, yes, we can do that. We can determine the rate of the global licensing rate for multiple SCP portfolio, not limited to the UK patent. This is the UK's landmark decision, Unwired Planet case, decided in August of 2020. But the question is, how did the UK court overcome the territorial scope of the patent? They said this is a contract issue. More specifically, they analyzed the IPR policy of ETSI, which is a standardization organization, and they said under that policy, the UK court may decide the global royalty rate. They has the jurisdiction to do that. That was the reason why the UK court said they can decide the global royalty rate. But
And I think,
this,
sorry to interrupt, but it seems like a lot of this case law that you're probably going to go through is really tied back to that idea of, you know, people worry about that idea of comedy, right? Of not comedy, haha, but comedy, COMITY, like the idea of one court having respect for another court from another country. And I guess that maybe the construct here is sort of the idea that the parties are coming forward, that they are each personally or individually sort of appearing before the court. Is that sort of your view as to why these courts are coming up with these kinds of decisions that would bind these parties on a worldwide basis? Is that sort of the idea underlying a lot of this?
that's a very that is a very, very controversial issue. Yeah, and I really want to have other panels' opinion as well. Yeah, let me talk a little bit more after that.
Sure.
But I think that how do people understand this decision and take care of this decision is depending on the situation of that person, of that company. For patentee side, it is a very good decision because they can have the decision on the global patent portfolio, decision on the rate for the patent portfolio as a whole. That is a very effective to resolve the disputes on the SCP licensing at one time. It is very effective. But on the other hand, I think that the implementer side would have a different view on this. So I think that how do we think about this? How do we analyze this court decision? It's depending on the situation, and I would love to have other panel's opinion and also your opinion as well.
Yeah, maybe if we look at the global implications of the case, so at least my understanding is that they're slightly limited by the fact that the UK court still kind of set the prerequisite that this leads to a UK injunction if Huawei does not accept it. So it's still not a global rate setting in the sense that it would have any kind of implications on other patents than the UK patents solely. Then they kind of found for convenience that the rate would still be a global one if Huawei accepts it for the avoiding the injunction in UK, which of course Huawei had agreed to have a rate set for the UK market already. So it's a little bit different than setting a global rate per se, in my opinion. But otherwise, I fully agree with your description of the case.
Go, John, any thoughts on that, or?
This case, like UK court, probably, I think this decision definitely, in my opinion, is not a great example for the other countries. They try to set up a global rate, and then their injunction power is not going to be strong enough, right? Because even if you don't apply and then you got an injunction in UK, the market is kind of limited. It's not big enough. And then they set up a rule here for people, like people immediately figured out, I'm going to go back to China. It's a big market. We're going to do the same thing. You know?
I think that was sort of the feeling I had was, I can certainly understand, Akiko, you're talking about sort of the idea of logistically this idea of a single court and going to a single court and kind of resolving separate across the world is incredibly appealing. Anybody who's ever been involved in any sort of patent litigation where you're trying to sort of onesie twosie find large enough GDPs that you can draw damages from on a portfolio, it's a difficult thing to do. For me, I recall when this case came up, it was sort of, I think mine was sort of a little bit of a fear where it was sort of like the UK is not quite big enough for this. It's going to be a blueprint for, I think, other countries to do sort of worse things, perhaps, than I imagine the UK court might do. But yeah, it seemed to me, it was one of those things. It was once the case had come around and there was that kind of briefing on it, it just seemed like this is going to go forward. And if the UK doesn't sort of, make itself the de facto place to go, then somebody else is going to, right? And we see that in litigation all the time. Certainly in the US, you have, Eastern District of Texas, Western District of Texas, you have like to-go places, if you're a patent holder, to sort of get the best sort of justice. So venue shopping is sort of not really a new idea, I guess.
All right. Wonderful discussion. Okay, I just want to mention briefly that the recent development of China. I think it's not my area because I can't read the Chinese judgment, but I understand that recently, in August of this year, the China Supreme People's Court also decided that Chinese court may set global licensing rate under a certain conditions. That is a recent development in China, I recognize. And I'm a Japanese attorney, not a Chinese attorney. So if you, any of the panel know more about this situation, I would love to learn from our panels. Nothing.
Well, like for China one, I think basically his the first one, the defendant is come from China, like Huawei, right? And then Huawei actually is started that one. Huawei started actually suing, have a declaratory judgment suit in Nanjing Intermediate Court. And Nanjing Intermediate Court basically saying we can issue a anti-suit injunction against Conversant. That is a case. I think that case also went up to the Supreme People's Court. The Sharp versus Oppo is not the very first one. That one I don't know specifically whether the Supreme People's Court said the China court can set up a global license rate or not, but it definitely say the China court can issue an anti-suit injunction against the case. So that is the first one. And then you see people just learned, okay, we can do that. And Akiko, you just go ahead for your next slides. There are several cases come up. Then,
yeah. Thank you for your great introduction. So now we are going to talk about the anti-suit injunction, which is also the very hot topic worldwide. Okay, then what is anti-suit injunction? I think many of you know what is the anti-suit injunction, but maybe some of the audience doesn't know what is the anti-suit injunction. So
prepare to be afraid. This is a scary concept, frankly.
Yeah, so let me briefly talk about what is the anti-suit injunction. So as I said, SCP dispute has an international nature. And then issue here is which country's court the party may want to use to resolve such international disputes. Okay, to explain this movement, I prepared a hypothetical example here. Okay, if the parties could not reach the agreement on the SCP licensing, SCP holder may want to sue the implementer, bringing infringement action, but where? In the patentee-friendly jurisdiction, maybe. for example, in Germany, in India, or UK, something like that, then the implementer may be unhappy about this situation and may want to dispute in another jurisdiction, which is more preferable to the implementer themselves. Let's say in China or its home jurisdiction. Then in this hypothetical scenario, implementer brought a declaratory judgment action in SCP holder first brought a patent infringement action in country A, and then responding to that, implementer side brought a declaratory judgment action in country B, and then they apply for anti-suit injunction, so-called anti-suit injunction, to require SCP holder to withdraw the infringement action pending in country A. And then country B's court issued the anti-suit injunction. Then responding to that, then now SCP holder side applied for anti-suit injunction to block the anti-suit injunction to prevent implementer to enforce such anti-suit injunction issued by the country B's court. And then
where does it end, essentially, right? Yeah, anti.
That's
So this all
crazy.
sounds like insane, but what you're going to tell me in the next slide is this is happening, right? And people are facing financial penalty for failing to drop suits outside of one venue versus another.
Right, right. Yeah, that's crazy. Yeah, but that is actually
But
happening
not.
as well.
but reality, right?
Reality.
Yeah.
Okay, thanks. So let me introduce just two examples of this field. One example is, as Rob mentioned in his slide, Samsung versus Ericsson case. In this case, first implementer brought a declaratory judgment action in Wuhan in China, and then SCP holder brought breach of brand and patent infringement action in Eastern District of Texas in the United States. And here, implementer applied for the anti-suit injunction in Wuhan court, and the court issued an anti-suit injunction as requested in December 2020. And one important here I would mention here is the scope of the Wuhan court's anti-suit injunction was very broad. They ordered SCP holder may not seek relief from any court, not only in China, but also globally. That was, let's say, global anti-suit injunction. Reacting to this, Texas court, SCP holder requested the anti-suit injunction to the Texas court, and the Texas court issued as requested anti-suit injunction in January 2021, where the court ordered the implementer not to take any actions in Chinese case, which would interfere with the US proceeding. And I want to mention here that the scope of the Texas court's anti-suit injunction was limited just in relation to the US. This is a contrast to the broad scope of the Wuhan court's global, let's say, global anti-suit injunction. Okay, that is one example of the anti-suit injunction. And then another matter is InterDigital versus Xiaomi. In this case, 3 jurisdictions, China, India, and Germany were involved. Here, implementer brought declaratory judgment action in Wuhan, same as the previous one, Wuhan in China. And then SCP holder brought an infringement action in New Delhi in India, which is also a patent-friendly jurisdiction, many of us understand. And then implementer requested anti-suit injunction and in Wuhan court, and Wuhan court issued anti-suit injunction in September 2020. And here, same as the previous case, and this anti-suit injunction issued by Wuhan court was global nature, global anti-suit injunction preventing SCP holders to apply for injunction globally, which is very broad. Reacting to this, SCP holder requested anti-suit injunction in New Delhi, where the infringement action was ongoing. And New Delhi court issued anti-suit injunction as requested in October 2020. Well, it is very good to the SCP holder, but a point here is that Wuhan's anti-suit injunction had a global effect and covers other jurisdictions as well. So that anti-suit injunction was also an interference for SCP holder here to access other courts, including the German court. So in order to bring action in German court, SCP holder in this case needed to request another anti-suit injunction in addition to the anti-suit injunction in New Delhi in India, in Munich, in addition to India, Munich as well, Munich in Germany as well, and reacting that request, Munich court actually issued anti-suit injunction in November 2020, and such anti-suit injunction was affirmed in January 2021. And one good news for SCP holder about this Munich court decision is that here Munich court said that applying for an anti-suit injunction generally trigger the finding the implementer's unwillingness to take a FRAND license, which would be a reason for German court to issue an injunction based on the SCP under the four-way ZTE framework. That is, I think, in general, a good judgment for SCP holders. Thanks.
Yeah, and I think, if I'm not mistaken, at least one of these cases where you had sort of competing anti-suit injunctions and anti-suit injunctions, you had financial penalties that went along with that, right? In terms of if you're not dropping those cases in other jurisdictions, other territories rather, you're subjected to financial penalties. To my mind, it's hard to imagine a litigation going worse for either side where, you kind of can't make two countries that may or may not get along globally sort of happy by virtue of the fact that you're in both courts. I mean, and I guess the answer then is, when everything has gone sort of haywire like that, where, the plaintiff or the SEP holder, say, is sort of doing well in one court and terrible in the other, and the implementer is doing well and doing terrible in the other court, in the other way. How do we dig ourselves out of that? How do we end up not being there in the first place? I mean, Patrick, do you have any thoughts on better ways to do this than litigation?
Yeah, I suppose if you have ended up in that place, then probably it starts to be a little bit too late to do anything creative anymore. But based on our experience, at least, usually when there is a company that's actually willing to take a FRAND license, and of course, if the licensor is willing to grant the FRAND license, then an arbitration is usually kind of the most convenient way to agree on a resolution between those parties, because then you can set the rules for that process bilaterally, and then you can actually agree on the scope of the matters to be arbitrated, and you can do it effectively and usually with people who are kind of specialized in those topics. So if there is a company that truly is willing to pay FRAND, if there is a licensor that is willing to give a FRAND license, but they just can't agree on the value, then usually arbitration would probably be the best solution.
Yeah, and I mean, to me, having been a litigator, arbitration is always sort of viewed as not as nice a solution, right? You may not get any sort of appeal process. You may not have any real guarantee that the law is going to be applied. You may have weird rules about discovery. But are the three of you seeing that change where people are being more willing to sign up in the face of this sort of really complex, sort of nightmare-ish sort of litigation? Are people more willing to sign up even early on in those negotiations to, hey, if we can't work this out, we'll submit to an arbitration? And then I guess the follow-up to that is, are there specific places that we're seeing as sort of hubs of arbitration?
I'll actually just first comment on something you said about the applicable law, that we may not, in an arbitration, we may not always kind of work by the law. So in these cases, you have so many different laws that apply at the same time. So it's always a big mess between the different rules anyway. So I mean, there's going to be no matter which process you work with, there's going to be questions about was that law appropriately interpreted, for example, and so forth. So there is no clean solution, and the arbitration is, from that point of view, probably the best solution in a situation like this, where there are just multiple different factors that play into the resolution.
Yeah.
And then Gojan or Akiko, I mean, any thoughts on, we had seen, Hong Kong used to be sort of a big place for arbitration. Japan, we see Singapore maybe a bit more these days, but I think there's always been a concern about sort of arbitrations done in the US and whether or not those would be accepted by foreign courts. And so it seems like you're always looking for sort of a bit of a neutral ground, but one that's still respected. Any thoughts on that in terms of, if somebody's out there trying to figure out where the right seat for an arbitration would be, if they're starting to go down this road and starting to suggest, what the framework's going to be, what does that look like?
Yeah. Regarding the arbitration, I think that currently arbitration, some of companies do not want to use arbitration to resolve the SAP dispute because of the confidential nature of the arbitration. We can't really expect what will be the outcome. So some of the companies do not want to dispute in arbitration, but at the same time, I think that many other people consider that arbitration would be effective because it's cheaper and efficient, because in many disputes, companies are disputing in the US, in China, in Europe. That's crazy. So arbitration would be a very effective tool to resolve the SAP-related disputes. And I recommend that Japan, please come to Japan. Recently, Japan launched an international arbitration in Tokyo, so-called IACT, to effectively and efficiently resolve the SAP-related disputes. So I would like to promote this initiative, and please come to Japan to use arbitration to resolve the SAP-related dispute. That's my view.
Singapore certainly tried very hard for many years. They want to become a regional IP center, IP hub. So for regional IP hub, it's very difficult for bring parties to sue in their court because the remedy there is very limited. You don't have much injunction power. Even if you issue an injunction, the market is so small, right? So it's not going to be very effective. I think they realize that. They probably now really try to foster its arbitration and want people to go to Singapore to arbitrate. I think Singapore have some good, I think have some strength. Like there's, for example, it's English speaking. That's probably a big part. And also it's common law, basically. Although this arbitration is different, but Singapore is a kind of a common law. And I think probably it's more acceptable by both the patent owners. Patent owners normally is from Western side. So because of Singapore's a background, it used to be a colony of England, right? And then it's also common law based, and also kind of probably more acceptable by implementers. Implementers is mostly in East Asia area, particularly in China. I think that is, I can see Akiko is not just against Japan, but I think it's Singapore probably, if there is one center, Singapore, I see Singapore probably have a good chance. But personally, I think it's going to be hard. it's going to be hard. I think the biggest problem between the owners, the SIP owners and implementers is kind of they have to reach some kind of compromise, because the implementers mostly is the Chinese players, and they are doing business in a very, very thin margin. So they really care about how much royalties you're going to ask for me. And then for the SIP side, SIP owner side, they say, okay, we want to ask this one because in the Western countries, we all do that. But if you give them, still ask them this rate, and they said, we're not going to make any profit. You know, why we do that? That's why I see is this kind of a tension between different jurisdictions. Whenever you started a lawsuit in US, in Western countries, we can probably expect a similar suit in China happening like that. And this anti-suit probably is not going to work, you know, because you issue an anti-suit, the other side issue anti-suit. This is not going to work. Whether this like a global rate, whether is that going to work out or not, I don't know. But in the end, I think both sides have to kind of reach some certain compromise for that.
Yeah, it's always been one of those things that is of great interest to me is how thin, how narrow, how slim margins are on a lot of these products.
Yeah.
You know, it's always one of those things in, you know, I think it's a plaintiff's attorney thing in the US where it's like, well, you'd pay $1 more for your phone, wouldn't you? And that's all my client wants is $1. And it's like you're thinking to yourself, like $1 per device? Like, holy cow, that's a huge amount of money. So yeah, no, it's everyone is sensitive to licensing rights for sure. Which brings us on to our next topic. You know, market rate. You know, how do we determine a market rate? I mean, do we? You know, we talk about SEPs obviously, and SEPs are important, but I think anybody who's been involved in, you know, there's always litigation even on the fringes of standards. Frankly, you know, there may be patents that are sort of not specifically required by a standard, but are nonetheless sort of the only way that anybody would really implement that standard, where, you know, and they kind of end up almost being like SEPs, but almost stronger in some respects because maybe they're not tied to some FRAND obligation. So, I mean, you know, John, going back to you, I mean, how do we figure out how many players there are out there? I mean, how do we know when we've kind of got everybody in the tent, right? I mean, I would think there's a lot of SEPs that have been identified, probably not a lot more maybe around the standard itself, but there's still going to be a lot of important patents, and some of them probably are unknown at this time.
So I did some research and find out the major players in 5G domain and certain companies. And by the way, this 5G standard is started. It's like in 2014 or 2015. So it's been a while. It's been for many years. So but that does not mean all those standard essential patents is already there. There's still room for new ones, but I guess it's going to be incremental. It's not going to be a huge fundamental increase change. Currently, somebody like I think it's a UK firm called IPBC, and they did some kind of survey. They find out some data. They find out the major players nowadays is the number one seems like is Huawei, and followed by Qualcomm and ZTE, Samsung, Nokia, and LG. So, and it find out it's kind of very concentrated, these SEP cases, for like about top 10 companies, they own over 80% of these self-declared SEP cases. And the top, if we count for top 20 companies, and it's actually the ownership of all these like declared SEP cases is over 93%. So it's very kind of concentrated in major players' hands. And by the way, all these self-declared, you just simply declare to standard organization standard setting organization basically say, you say this patent is essential patent, but in reality, not all of these is going to be actually standard essential patents. It turns out probably is between 20 and 30% is going to be actually the standard essential, even though they self-declared as a standard essential. But among all these actual standard essential patents in the litigation, how many is going to be valid? That is still not a huge percentage. I would say probably half of them and it will be valid, and half of them probably will be invalidated. So for the late players, and among all these participants of standard setting organization, because our audience today probably is primarily from Taiwan. So I say this one is the only company I saw over there is MediaTek. I think is on about 1%, a little bit less than 1% of this pad. So for the players here, I don't see, if you're not a smartphone handset manufacturer, and I think that one of the major applications, which is different, which is extension of the previous, like a 4G, 3G, is a 5G is going to extend it to broader areas, including IoT, Internet of Things, like a vehicle, connected vehicle, and all different kind of application. I would say if you are a late player or small player, if you want to play in this domain, probably you should focus more on something called a non-set, focus on applications and how we're going to apply this 5G technology to different areas, like IoT, or like nowadays I hear people apply this 5G to even coal mining places, like a seaport or different areas, or hospital or healthcare or different areas. This is the area I think there's a lot of room for people to play. And still there's a lot of opportunities for people to file patents in this area.
Yeah, no, to my mind, that always does sort of make sense, that it's kind of, there's the steps first, and then there's the application, of the technology for specific application, right? And again, sometimes those are incredibly valuable to have. So the complexity of sort of identifying who the players are is one thing, but then, the next complexity is the number of entities who now need to care about getting a license to this IP is massive, isn't it? I mean, compared to what it used to, if I look at 4G as an analog, I mean, aren't we looking at sort of an order of magnitude bigger? I mean, Patrick, any thoughts, or Akiko?
Yeah, so certainly some of the markets, like the handset market, are somewhat consolidating. So the number of players are, of course, going down there. But I think the expectation certainly is that, for example, on the IoT side, we will see a large number of players who will need to look into these issues more thoroughly.
So yeah, to my mind, Nikiko, you could speak to this. I mean, are you seeing a lot of new, less sophisticated entities either bringing resource in-house to try to build an IP department, understanding that they need to at least have some ability to negotiate these things, or are they relying entirely on outside counsel? I mean, how is this kind of working in practice?
Yeah, it's a very big issue right now. Yeah, as everyone says, in the past, only the limited players in the specific industry, the telecommunication industry, needed to take care of these issues. But however, now as Gwenjun mentioned, now the IoT technology has been developing dramatically. Activity increased in recent years, especially in a 5G era. More and more players in other industries outside the telecommunication industry needs to take care of this SCP and brand issue. So that now in the past only telecommunication industry, but now car industry, automobile industry inevitably involved in this field. Like Avanci. So many industry would need to take care of these issues now and in the future. And it's and also as the as this slide mentioned, there is a very difficult issue on the how to calculate the royalty rate, smallest suitable unit or entire market value. That is one issue, and also the so-called license to all or access to all issue. That brings the issue who should owe the licensing fees within the supply chain. That is another issue. So many players, not only OEMs but the suppliers in various industries would need to take care of these issues, and many of them do not know what is the issue and what is the ground principle and how to negotiate the SCP licensing, because the SCP licensing is somewhat different from the normal licensing practice, because we need to comply with the FRAND principle to avoid injunction from the implementer side and enforce from the patentee side. So they need to take care, start as soon as possible to learn how to negotiate the SCP licensing now or in the near future, because many industry would be inevitably be involved in the SCP world now or in the near future.
Yeah, it never ceases to amaze me how I'll talk with entities who are less sophisticated, and somehow FRAND comes across as like, well, it's going to be cheap because it's FRAND, and it's like, I don't know where you got that from, but that's the F doesn't stand for free or cheap, or yeah, it's always surprising to me. But it sounds like what I'm hearing from the three of you and the audience, you heard it here first. 5G is going to be an incredible opportunity for everybody who's got some IP experience to keep gainfully employed. So that's a fantastic thing to hear. I know I'm happy about that. And that kind of brings us on to kind of that next issue, which is, as we talked about before, Akiko, you were just talking there about sort of, how do we figure out this licensing scheme, and how is the license identified? What products is it on? Frankly, do people want collective licensing, or do they want to kind of reach out to individual entities? I mean, to Goshan's point earlier, like, these are thin margins, right? Do I want to license to 3,000 patents that 20% are all that applies to me, or do I want to be able to kind of pick and choose a la carte? What direction is this going, and what direction do we think it'll go? I mean, can you guys give us some thoughts on that?
So I think it remains to be seen. Of course, as you have seen, Avanci has tried to come up with some type of a collective solution. I don't think the licensees have exactly lined up to take a license through that solution either. So it doesn't seem like that was probably the one stop that it was intended to be, but we'll see how it develops in the future. With regards to the razor thin margins, so I kind of agree that that's probably a challenge, but effectively what you're trying to say there is that the companies are trying to avoid the payments overall, because of course, if they're paying a FRAND compensation, then all of the other entities in the business would be paying the same as well. So it's only relevant that you can kind of avoid the payment in its entirety to avoid or to protect your profit margin in that space. So I think that's a little bit what you're seeing now, that companies that are not willing to take a license in the first place would have alternative options to do so, but are not kind of doing it even if the licensors would come together, as in the case of Avanci, for example.
And so my understanding is Avanci is sort of established a bit of a, rather than a rate card, it's something of a flat fee. Is that right?
I think so. That's a flat fee arrangement. If my understanding is correct, the 4G at least the 4G IoT program, I think that they applied a flat fee of $15 per vehicle, if my understanding is correct.
And I saw like I just checked their website. Avanci,
great.
in terms of 5G, they actually, I don't know the flat fee rate yet, you know. In terms of 5G, they just recently announced they're going to have set up a pool for 5G for connected vehicle. That's probably the first area they're studying in the 5G field. This one, you know, is Patrick. Is that true? You probably know better than me, you know.
So if your question is that is this when they're starting the 5G area, so I believe that's correct. Of course, they have been very active already with the previous technologies and trying to license those to the automotive makers.
I haven't heard of their flat fee rate yet for like a 5G, but of course, like in response to Rob's, your question is whether the implementers would rather to license from a pool instead of individual. I think most implementers would rather do it with a pool because it's easier, and also it's also for them easier for them to calculate how much like a profit margin they still have left, you know. Because if they do individual, they just each one by one, you never know what the next one is going to come up with, you know.
I think everybody loves the idea of a pool until there are 5 of them, and no one can agree on which one they absolutely need.
But I think even for Avanci, I see like at least I noticed there's 3 big players is not there yet. Huawei is not there, Samsung is not there, LG is not there. I checked their website. I could have missed somebody, but I think I didn't find these 3 big players over there yet.
Right,
Well, I've always thought Nokia was a big player, right? Patrick, you'd agree with that?
Yeah, Nokia is part of it. Seems like,
Oh, sorry.
So I'm just going to highlight that I think theoretically most people agree that companies probably want to go to pools to get the licenses. If you look at the empirical evidence of how, for example, Avanci has worked, it will be interesting to see if that actually is the case when we actually look how companies behave. So, you know, I think on paper that's exactly the way it should work, but I'm not quite sure if we are there with the empirical evidence yet.
Patent pooling is absolutely an efficient system, both for the patentees and the implementer side. That is, I think, that common understanding. But as Gonjon mentioned, especially unsophisticated implementer need to understand that entering a patent pool it's enough, because there is patentees outside a patent pool. So that is one thing we need to understand. That is one thing. But other than that, I think that many people think that the patent pooling mechanism is a very efficient system. I think many players understand like that. And in the past, I think patent pooling system involved in antitrust issues. But now I think that there is a shared view in general, at least in general, that the patent pooling is an efficient arrangement to reduce the transaction costs. That is preferable for both patentees and implementers. For example, one example is that the business review letter regarding Avanci's 5G IoT program issued by the U.S. Department of Justice Antitrust Division. I think that was last year, where they stated clearly that Avanci's 5G platform is unlikely to harm competition. So
it does feel like pools for a while have been sort of seen as pro-competitive. And I think it is just that reduced friction and, you know, less payouts to lawyers, which should result in lower consumer prices. I think that's probably the thinking there. You know, it's always possible. There does seem to be some shifts, at least in the U.S., around antitrust law. So it'll be interesting to see. And again, it's always interesting. I think it's just really a question of how smoothly does it operate. and it feels like in the past, at least from my view, around a lot of standards, you ended up having a couple of big players, and it seems like since then we've been on this track where it seems like it's hard for anybody to kind of establish the pool that everybody else is drawn to. But we'll see, and maybe Avanci is there early enough in time that they'll drive everyone that way. In terms of what thoughts. Obviously, this is a great time if the audience has any questions, but any thoughts that you have on kind of the next 5 years and sort of what you're looking forward to, what you're concerned about with respect to 5G licensing, just any thoughts? Do you see the anti suit injunction getting better, getting worse? Do we see arbitration taking off, but then, territorial courts refusing to take determinations from those, arbitration panels? I mean, where is this headed? I guess if you look into your crystal ball. I'm going to start with you first, Gojan. Yeah, go ahead.
Okay, sorry. I think one area might be I expect in the next 2 to 3 years, maybe some court is going to make that decision. It's about whether a licensor, the owner, patent owner, can get the license rate based on the entire product or just the smallest sellable unit, because it's a uniqueness of this 5G. Because 5G used to be a handset, right? Handset, so far is that one. People still do that, and although some people challenging that, it hasn't been successful. But I think when the 5G technology is being used in a much bigger area, like an automobile, that might be an interesting area. I would say some court is likely going to make that decision.
Boy, people are going to run there, but no, I that doesn't sound, if I think of, the kind of car that I had when 4G sort of came into view. It's a very, very different car in terms of infotainment, in terms of any kind of ADAS, anything like that. So yeah, I mean, it's a fundamentally different vehicle these days. And from a damages perspective, are people making the determination to buy that car based on those changes, right? Because maybe a lot of the rest of the car isn't that different. It still might be a petrol-powered engine. Maybe it's an EV, but those weren't unheard of at the time, 4 or 5 years ago. So it is the determination, is the reason to buy that car based around the connectivity and the system involved. And if it is, then you do start walking yourself towards an EMV type analysis where this is the thing that makes people want to buy this car, and so therefore the royalty is appropriately based there. And any thoughts on that, Patrick or Akiko?
Yeah, so I actually, in licensing discussions, we don't very often see the smallest sellable unit discussions anymore. So it was something that was maybe discussed earlier on in the industry. It's a very much a question of licensing level, though. So I think that question is certainly something that will be absolutely key, especially in the IoT space going forward. So I think that's something that I look forward to seeing in the next 5 years, at what happens in the IoT space with regards to licensing level and with regards to how the industry plays out on the licensing overall. And then, as you said, the anti-suit injunction game will be very, very interesting to see, but that seems like an area where you have to have some clarity sooner rather than later, because it just kind of can't continue like this between the countries.
You're right. I totally agree with Patrick's view. Licensing level as it's an unresolved issue and a very important issue, especially in the IoT world of 5G era. And yeah, case law hasn't resolved this issue, and also industries haven't reached a common practice as of today. So this is a very big issue, and I think that the government agencies like Japan and also the EU Commission yeah, considering these issues, that's my understanding. So we need to look at the those development in the courts or the government agencies, and also we need to try to reach the common practice to efficiently negotiate the licensing negotiation in SAP world.
Does anybody expect, an organization like WIPO, for instance, or somebody like that to establish some mechanism or suggest some mechanism to various countries? It's one of those things we can all say, like, yeah, it's not working right now, but there's no intergalactic overlord we can take it to say, hey, can you figure this out for us, right? This is the reality of the world, is that you have different countries. They all believe themselves to be sort of equally powerful or equally important. So it's a difficult thing to work out, but you could imagine sort of, organizations with intellectual property leadership sort of seeking to drive at least regional agreement, right? Maybe an agreement between, Japan and Korea and Singapore and some other, parts of Asia or parts of Europe. Has there been any development there that any are aware of, or even discussions, or anything of note?
I haven't heard much about that. I think that is looks like a good solution, but it seems like it's idea, right?
Yeah.
In the reality, we are kind of have whether in terms of country, among countries, we kind of have mainly SAP owners and mainly implementers, and in terms of whether we should license to what level, and then we also have owners, and then it's kind of pooling, I think. But someday we have to, somewhere we'll reach a balance over here. For that part, I'm still optimistic.
Yeah, balance is important.
Mm-hmm.
Yeah, and I apologize. We are now in the part where I'm asking questions we have not spoken about in the prep. So my panelists are like, "Where is this coming from? We never talked about that." No, it's interesting. And you can imagine that a lot of these countries have a vested interest, as you say, in sort of supporting their piece of this. Do they represent, is it primarily SEP owners? Is it primarily implementers? What kind of implementers are? Is it IoT? Is it auto? Is it, what areas matter to them? Any thoughts from you on this issue, Patrick? Or
So I think it's one of those that remains to be seen. Usually bilateral discussions have worked very well when there has been a willingness of both sides to respect the process. Now, of course, there starts to be a lot of ways in which you can avoid, or at least try to avoid, the payments for a certain period of time, and a lot of companies try to use that option, of course. So we'll see how it develops, but the bilateral negotiations have actually worked very well in the FRAND kind of process before, and I have no reason to assume that they wouldn't continue to do so between two willing parties.
Yeah, right now, the complexity is existing in the SAP world. There are so many issues we need to understand, and many of some of those issues are not being resolved in the courts or the government agencies. So, but in general, FRAND principle, we in general, one thing is that both sides need to negotiate under the FRAND principle. What is FRAND principle? That is not clear enough, but at least we need to negotiate under the FRAND principle. And I hope that if both parties negotiate in good faith under the FRAND principle and under the case laws in various jurisdictions, I think that people would reach the good agreement. But I suspect that many players right now do not fully understand what is the FRAND principle, including and other issues, including European four-way versus CTE framework. So first of all, we need to learn clearly and fully what we need to do. And then we need to try to make efforts to reach the common practice, which have a good balance between the patentees and the implementer. Yeah, as Gunjo mentioned, balance is a very important thing, especially in the SAP world.
Yeah, years and years and years ago, when I was a young attorney, we did some piece of work for somebody, and it was about basically what could we take from the case law in the United States around FRAND, and what does that mean? What does that really fundamentally mean? Where are the lines? And as best I can recall, we weren't able to really figure out anything. It really didn't seem to have a whole lot of import, other than people seem to feel better if you said, oh, it's going to be licensed under FRAND term. So yeah, it's interesting. We actually do have a question, so I'm thrilled about this, from the audience. Any recommendation for Taiwanese vendors under anti-suit court war? Basically, where if you were a Taiwanese vendor, where do you start? If the negotiation is going poorly, and I'm adding this part, but if the negotiation is going poorly, and you're a SEP holder, where do you start your litigation? If you're an implementer, where would you start your litigation? Any advice that we have for potential Taiwanese clients?
I would say if you are a SEP owner, start with Germany. But if you are implementer, start with China court. Just my observation.
Yeah, I got that same observation when I looked through Akiko's materials. So yeah.
Yeah. As Gunjun said, Germany is in general patentee-friendly jurisdiction, and as for the SAP litigations, Germany is very preferable to SAP owners because they could get injunction in German courts. So, injunction is a very big tool to reach the good settlement. So, yeah, I agree. The selection of forum is depending on the situation of each case, but in general, Germany is a very good jurisdiction to patentees.
And I'm going to say that. I'm going to say that. Avoid litigation and offer to take a license under FRAND terms and arbitrate those FRAND terms between the parties. Then everybody will be happy.
Great. Yep.
There you go. I'm not sure how much time we have left here. Sorry.
I think we already exceeded.
Yeah.
I feel like we've exceeded. I'm kind of waiting for somebody to come in with a shepherd's crook and pull us off. And there they are.
Me today.
All right.
Okay. Yeah, we're just about out of time. So this is the last chance for the audience to share any questions. And I'm sure the speakers would be happy if you reached out to them privately as well if you had anything that comes up after the event. And whilst we're waiting for that, it just falls to me to thank once again the speakers for the 5G licensing and focus session, Akiko Araki, Grojun Zhao, Patrick Hammerin, and of course facilitated by Rob Calico.
I want to pass along that thanks as well, because it would have been a horrible thing if I tried to talk about any of this. So I very much appreciate the three of you being here. Thanks so much.
Thank you.
Thank you so
It
much.
was a great session.
Rob,
It was a great session.
It's such a pleasure to working with each other here. Yeah.
Yes,
absolutely.
Me too. Thank you so much, everyone.
Thank you.
I don't believe there's any more questions. So once again, thank you, and thank you to our speakers from earlier today, both in the patent world of 5G, 6G, and the keynote by Tomonori Beku. That brings to a close the morning session of IPBC Taiwan. Please join using the same link you used today to log in this afternoon at 1:55 p.m. local time, where we'll have an introduction from ITRI and the 5G Industry Innovation and Development Alliance followed by a keynote from Dr. Zhengming Wu at Honhai Research Institute and Foxconn, and then closing off this afternoon with a 5G economy and innovative technology discussion. I look forward to seeing you all shortly. Thank you again, speakers. Have a great day.
Thank you.
Bye.
Have a great
Thank you.
day. Bye.